Are live. All right, I'll keep my eye on the attendees, give it a moment while people join, and then we'll get started shortly. All right, I see people filling in. We'll give it another minute. All right, maybe one more and then we can get started. All right, looks like it's leveled out. I'm sure people will continue joining the first few minutes as well. So John, whenever you're ready to go ahead.
Sure.
And kick it off.
Good morning, everybody, and thank you for joining us today at our roundtable here. We have really good topics going on, good pertinent topics as well. A lot of these have hit in the last couple of months, and we are trying to give you a better explanation of why we're doing the things that we are and what's going on in the world that we operate in. So we've got several speakers today. Mon Lee is joining us from Nisivoccia, Jason Martucci from the NJDCA, Bob Beinfield and Michelle Lukopoulos from Hawkins, Delafield and Wood, and John Reinhardt as well. He's going to help me out here. He's going to monitor along with me any Q&As that you might have. Please, if you have any questions, throw them in the Q&A chat box there down at the bottom, and we will get them to the presenters as they're presenting. I'll usually wait for them to take a breath before I interrupt them with a question. But again, we have a lot of topics that are here and now and that you could be going through, including our first one, which our presenter is Mon Lee. She's going to talk about the 2023 appropriation cap. You know, I can't see a show of hands, but some of you, I'm sure, have already introduced. So this one might be, you know, in your rear view a little bit, but there could be a lot of people on here who still haven't introduced. I know I have about a little more than half of my clients at this point who have not introduced, so this could be a pertinent topic for you. We will be throwing up some polling questions throughout to make sure you haven't fallen asleep. We want you all to get your 3 hours of credits, and we will be taking a break in here and there as well. So please answer the questions as they come up and get you all the credit that you're going to be entitled to. So we got about 60 people on with us today, so a nice sized crowd. There's about 75 signed up in total, so hopefully they all get here quickly. But we're going to get right into things with our first topic about the 2023 appropriation cap exceptions and the opioid settlement guidance. And Mon Lee's going to do that. She's a partner with Nisivoccia here. Mon specializes in performing audits for county and municipal governments, school districts, fire districts, and authorities, as well as federal and state grant funds. She's a frequent industry speaker on topics such as how to prepare for your audit, understanding school board secretary reports, accounting for capital and construction projects, are just some of the topics that she's spoken on recently. Mon has extensive experience in financial advisory and consulting services, which include review of budget, design of internal control accounting systems, assistance in various debt issues, refunding, and budget reviews. So I can tell you this, I've been a partner with Mon now. Mon's been a partner with us, I'd say, what, 3 years now, Mon?
Yes, this is my 4th year, yes.
4th year, so 4th full year. Proud to have her as my partner, does an excellent job. If I need an answer to something, one of the first people I go to is Mon Lee. So excellent when it comes to single audit and issues along those guidelines. So without further ado, Mon, floor is yours.
Thank you, John. Just want to make sure everybody can see the PowerPoint. All right.
Yep.
Well, good morning, everybody. Thank you for joining us. For my portion of the program, as John mentioned, I'm going to go over the local finance notice that the division issued last month, 2023-04, on the additional 23 appropriation cap exceptions and the guidance on opioid settlement. If you attended one of Tina's webinars through the league, or if you already introduced your budget, as John said before, you probably already know most of this. And if you are planning to introduce in April or later, then hopefully this will give you some ideas. In any case, we feel that this is important to go over in the midst of budget season. So LFN 2304 granted additional exceptions to the municipal appropriations capped. It's only available for the 23 calendar year and the 24 state fiscal year budgets. It lets you move increases for certain appropriations in excess of the 3.5% over the prior year to outside cap. So these appropriations include garbage and trash removal and disposal, recycling, PRS and PFRS employer contributions, gas and diesel fuel, and lastly, workers' comp insurance. When Tina reviewed these cap exceptions during one of the budget update webinars, she did mention that they are still trying to figure out if municipalities would be able to make a cap-based adjustment in 24 to bring it back inside cap. So there's no guarantee as of now. These additional cap exceptions are not a requirement. That is, you're not required to move the excess over the 3.5% outside cap. So let's say that the calculated amount is $5,000, but you only need $2,000. So you can just move the $2,000. You're not required to move the full $5,000. We've been recommending to our clients to use the 2021 appropriation cap bank first, since it's going to be expiring if you don't use it in the 23 budget. Then if you still have an appropriation cap issue, then you can consider moving the excess outside cap. In light of inflation and increases in, well, pretty much everything, it's best to keep the inside cap appropriation base as big as possible for the following year. Another idea that got tossed, around in the office, and I have to give Bud credit for this, or maybe I'm throwing him under the bus, is to move the allowable amounts outside cap, even if you still don't need it, but also keep it inside cap and then anticipate more fund balance. That's the offset. But the caveat is that you need to have a resolution ready and approved right after the budget adoption to cancel the inside cap appropriation so that you can protect fund balance and also your cap base. Obviously, this tactic is only probably going to work in limited places, because let's face it, if you can't even get your governing body to understand what the COLA ordinance is, I'm not sure if they will get this maneuver. Also, if you have people thinking that the use of fund balance is the end all and be all to solve all problems, this might not be the way to go either. So like I said, probably limited number of cases, but I want to toss that idea out there as well. The state added 5 new tabs to the levy cap workbook after the cap bank calc tab. So I just want to show you an example of what one of the new tab worksheet looks like. This is the one for garbage. As you can see, you will put the current year appropriation in cell C7, which is right here, and the prior year paid in charge plus the reserve amount in C10. So it's pretty much, you can only enter it in the orange spots or pink, depending on, the light. The amount you are allowed to move outside cap is on the bottom, right here in C16. Now, the one for gas and diesel, if you have utilities all broken out in your budget into like electricity, gas, etc., it won't be an issue. But if you have just one lump sum, like a lot of my clients do for utilities, and if you are under state budget review, the division will more than likely ask you to upload the support or detailed breakdown in FAS. If you're moving the allowable excess to outside cap on budget sheet 20, here are the FCOA codes to use. Just a reminder that you have to use the budget template version 23.1, since the early version don't allow for these codes outside cap. But if you've already input your budget onto the earlier version, you can just email Matt at the division and he will fix your budget doc for you so that you don't have to re-import your information. Katie, can you launch the first polling question?
Yes, I'll do that right now.
Thank you.
Yep. Okay, so the first poll is, will these new appropriation cap exceptions help your municipality in 2023? I'll leave it open for a moment and then share the results. All right, give it another minute. Okay. Looks like mostly yes.
Okay, that's good.
Okay.
Thank you, Katie.
Thank you.
Before we move on, John, Bud, do you have any other ideas that maybe I forgot to mention that you've been, recommending to your clients?
Mon, the only thing that I was thinking when you were talking about putting those exceptions outside cap and then using additional fund balance just to put an appropriation inside cap for the same amount. We were talking about something that you're not going to spend from, right? You're not, the appropriation would be something that you would want to be able to cancel by year end. So it had no effect on your fund balance for that year.
Okay, thank you, Bud. Now, just a few budget reminders. Group 1 is under state review for 23. And if you don't know what your group number is, it can be found on the municipal information sheet that can be downloaded off the division's website. It should be under the fiscal reports menu. The user-friendly budget is no longer required to be uploaded with the introduced budget. It's only required to be uploaded with the adoption. Health benefit waivers must be appropriated separately from group health. And that's the FCOA code 23-222. And it can't be included in the levy cap workbook. So you should not include that amount. DCRP, this is a change the division made for 23. They're no longer requiring or allowing us, depending on which way you look at it, to add DCRP to the PERS numbers on the levy cap workbook. I have an email actually probably like 2-3 years old from the division saying that DCRP should be included, but I guess because there's been a lot of confusion around this, they just decided to take it out. Depending on which reviewer you get, and depending on the year too, it seems like you get a different answer each year. So I think they just wanted to simplify it.
Hey, Mon,
Yes.
there's no formal question, but maybe Bud can also chime in as well. I don't know if you've had any that have come back from state review this year, being that was on your slide in the last one. I've had 2 so far come back for state review. I didn't know if you had any common points that are coming up, or Bud, if you've had any come back. But it seems like the same thing again year after year is sheet 38 when they're looking at your dedication by riders. That's the big one. It doesn't seem to be anything major, either that or we're doing them really well. But there's really no, I haven't seen anything, like a common thread in all of them. The only thing I will point out is if there's a new line of revenue, just make sure of that, because they harp all over that, which is fine. I mean, you're supposed to be doing that anyway, but that was one of the comments on one of my budgets that came back for state review. So do you have anything?
I only got one back so far, and all of the comments are on the AFS. So it's like 3 comments on the AFS. One's about the budget writer, like you said. Every year they kind of look, and typically what we the clients will tell them that we'll put a resolution in, we'll get it approved, and then kind of then 3 years down the line, it's kind of the same thing.
Right.
They are looking at the unappropriated grant sheets and making sure that they're in the budget, it seems like, because they questioned it. And then the other one, I think, is so minor that I don't even remember what it was.
Okay.
Yeah, I haven't had any reviewed to this point. I did have one situation though where a town would have otherwise been eligible for self-exam, but they were not eligible, and I didn't understand why. And I contacted Tina, and she informed me that one of the items was that they contracted with a outside CFO that didn't have an actual CFO appointed. So that's why they were ineligible for this year, which was something I didn't know.
Right. Question that came in while we were talking about this is group 3 also under review? And I just thought it was group 1. Anybody have any? I don't think it's just group 1 this year, right?
It's just group 1.
Right.
We good, John?
Yep.
Okay. So all the municipalities should have gotten an additional aid in 22 called Municipal Relief Fund. The state had released a revised state aid certification back in 22. I don't remember exactly when, but I think it was over the summer. I really didn't check because all my municipalities kind of introduced and adopted a budget before they had released that certification, revised certification. So on the revised cert, you will see this new item. And if you did adopt your 22 budget within a reasonable time frame, you most likely didn't anticipate this state aid in your 22 budget. So if that's the case, the amount you received should have been set aside in a reserve for municipal relief fund as of 12/31/22, and then you will need to anticipate it as revenue in the 23 budget. There's a little blurb on this in one of the LFN. It's 22-22. The last reminder here is to make sure the COLA ordinance is introduced before your budget introduction and adopted before budget adoption. What I do in all of my municipalities is I get them to introduce the COLA ordinance in January and adopt in February. This way it keeps the politics out of it, and I don't really get that many questions on it.
One question that just popped up here, Mon.
Mm-hmm.
Anne says that she's under review as group 3. Anybody on the panel have any rationale as to why people on group 3 would be? I mean, I know Bud just went into 1, but I know there's other reasons.
Yeah, I would contact the division, find out like I did. There may be a reason that you're not aware of.
Right. Okay. Okay, Mon. Oh.
These are the revised dates for the budget intro and adoption. Even if you introduced in April and adopt in May, I don't think my clients have really had an issue. I think once you kind of get into June, then the division is gonna start, hounding you about your budget and the status of where it is. Before I moved on to the next topic, Katie. Can you launch the next polling questions for me?
Yes, I can. Okay, the next poll is, have you introduced the 2023 budget? And then I'll share the results. All right. Make sure everyone responds. Looks like we're about half yes, some no.
Okay, I think it's still good.
Yep. Thanks.
Thank you.
Yep.
John, anything else on the budget before I move on to the next topic?
I just have one person that said their poll did not come up, so if you can email Katie, I don't know.
Here, let me try to relaunch it really quick and see if that works. If not, yeah, just send me an email.
Okay.
Oh, you know what? No, just send me an email because I don't want to clear the results. Yeah, I'll put my email in the chat.
Okay. So
Thanks.
Katie put her email in the chat. Please email her. And if your next one doesn't come up, let us know and we'll figure out what we got to do.
Yeah, I'll make note of it. Just send me send me an email on your response or whichever polling question. Thanks.
All right. So the second topic is on the national opioid settlement. Let me preface by saying that I'm not an expert in this, just learning this like the rest of you as the guidance comes out. In the 2304 LFN, it gives a brief background on this and has a link to the memorandum of agreement between the state and local units. Basically, nationwide settlements have been reached with certain pharmaceutical companies to resolve the opioid litigation brought on by various government entities against these companies. And the proceeds of these settlements are in various stages of distribution to many, municipalities and counties in New Jersey. The memorandum of agreement is about a little over 300 pages long. So that, when I first looked at it, it was a little bit daunting, but I realized later that there's just a lot of exhibits in there that, you don't really have to read through. Starting on page 35 is Exhibit A, which details the allowable uses for the settlement proceeds. And then it's about 12 pages long, so it's not a difficult read. And I would highly recommend that you read through this if you have these funds to spend. And starting on page 48 of the PDF is Exhibit B, which lists the government units receiving settlement proceeds. New Jersey starts specifically on page 177. And I have a link here so that you can, and the link is also in the LFN too. Certain municipalities already got some money in 22. I think we started getting questions sometime in the late summer on this last year. At first, we weren't sure and had reached out to the division, and they issued this finance notice 2304 with the guidance in it. But I think in the meantime, we had recommended to a client to put it in unappropriated grant, just because we weren't sure whether we can establish a trust reserve for this or not. So in the and I think some of my clients did actually submit Chapter 159 during 22 and it got approved. But anyway, the LFN made it official. You can do a Chapter 159, or if it's sitting as unappropriated grant fund as of 12/31/22, you can include it in your 23 budget as grant revenue appropriation on sheets 9 and 24. And as I mentioned before, there is no statutory authority for a municipality or county to establish a trust fund on the settlement proceeds, so you can't do a budget rider. So what can you use the funds for? funds should be used for the treatment and prevention of opioid use disorder and any co-occurring substance use or mental health conditions through evidence-based or evidence-informed programs. As I mentioned before, starting on page 35 of the Memorandum of Agreement, it details the allowable uses for settlement proceeds. I'm not going to go into all the details here. I'm just going to give the highlights. So allowable uses are broken down into two main categories. You have treatment and prevention. Under treatment, you are allowed to use the funds to support individuals in treatment and recovery, provide those afflicted with connections to care, address the needs of individuals involved or transitioning out of the criminal justice system, and address the needs of pregnant or parenting women with the opioid-related conditions. Under the second category, prevention, you can use the funds to prevent overprescription and ensure proper dispensing of opioids. An example of that would be education and training for healthcare providers and dispensaries. Preventing misuse of opioids can include funding media campaign or funding community anti-drug coalitions. The last item here is the prevention of overdose deaths and other related harms. An example of that would be public education relating to emergency responses to overdose. So there are other allowable uses which are listed on this slide. They include training and education to first responders, as well as provisions for wellness and support services for first responders. Support for interagencies planning and coordination between the state, county, and local level in the community. And also allowable would be training and research on opioid. Now, there are some additional requirements. Settlement funds should be used to supplement, not supplant funds that otherwise would have been used for approved purposes. So in other words, if you already have something in your budget that you're raising through levy, or you using your fund balance to fund certain, programs to address opioid issues, you can't use the funds to replace what you already have available. You're supposed to use it to kind of add to the program, or in other words, supplement the program. Funds can't be used to quote unquote reimburse the state or any of its counties or municipalities for past expenditures, except as may otherwise be required to refund the federal government. There's also a requirement to establish an advisory board at the county or regional level regarding how the funds are to be dispersed to the various entities. And then the last thing on here is that there is a 5% limit on administrative expenses. So the last thing I have here is on reporting. I don't have any more specifics than what I have here, because the Department of Human Services is still developing an annual reporting process. The first report is due no later than September 1st, and the counties will be required to report on how settlement funds were allocated to participating municipalities. And I just want to show you kind of really quick too, if I still have it up here. All right, so this is what I was saying before on the PDF. If I'm going to go to page 177. So it starts listing New Jersey, and there is no actual dollar amount. It's just an allocation percentage. But then if you read the top here, all allocations are subject to change. So, and then as I was doing research on this too, it talks about how, entities can decide to participate or withdraw from participation. And if that does happen, then their allocation gets spread out depending on, I think if a municipality withdraw, for example, then their allocation would get spread out among the county, or if the county withdraw, then their allocation gets spread out among the other counties within the state first. So there is no set amount, and I think that there's also a set aside funds for to reimburse entities on legal costs if there is direct legal costs in terms of if the municipality or county had any launched their own case against these pharmaceutical companies. So I think that is it. Any questions, John, on this topic?
I do not see any questions on the opioid topic, nope, or any other ones that are out there, so.
Okay. Yeah, my clients really haven't gotten that much money. Like I said, I don't know at the end of the day how much they're going to end up getting and how long. I think it seems like in one spot, it talks about that it's going to disperse over 18 months, but then in other spots, I read that there's going to be phases. And also there's only as of now, there's a select number of settlements, but then there could be more coming on as more companies settle. So that dollar amount probably is up in the air.
There was one comment, Mon, that came on while we were speaking here. We reached out to the county, and we've been working in a large group to determine how these funds, how to use these funds, the opioid settlement funds. We're actually able to use some of the to offset the cost of enrolling new police officers in the academy, provided we can show specific training that takes place that fits this description. So there's another use that they're coming up with. Do you see that in your
No, so in the 12-page in the agreement, the Exhibit A, there's 12 pages on the allowable uses, and it goes into pretty detail as long as it fits under one of those. But that sounds like it could, as long as it's related to the training is related to the opioid.
Exactly. Anybody have any other questions on this topic or the budget topic?
Mon, I'll jump in and do the last poll that we had for your topic if there's no other questions. So this last one is, have you received or expecting to receive any national opioid settlement proceeds? All right, again, if you have any problem with the poll, you can just send me an email and I'll go ahead and close it. All right, so again, looks like we're pretty split, but a decent amount have them, so interesting. Thanks, guys.
Well, thank you for everybody's time.
Thanks, Mike.
John, you want me to do the next one?
Yeah, sure.
So for our next topic is Financial Data Transparency Act and the New Jersey Administrative Code 5:30 Local Finance Board proposed amendments and new rules for 2023, which is going to be led by John Mooney and Jason Martucci. John Mooney, as most of you know, is a partner with Nisivoccia. He specializes in the governmental department. He specializes in performing county, municipal, school districts, college audits for their governmental clients with a strong knowledge of the complexities facing government municipalities in New Jersey. John is a trusted advisor to all their clients and elected officials. And I'm not going to go on because he's got too much written out.
It was
That's funny. So Jason Martucci, we didn't have your bio, but Jason, what is your official title down at the state?
Legislative and Regulatory Affairs Officer.
So,
I've got Jason's bio if you want to.
oh, you got it?
Yeah. Go ahead, though. You can. You sound like you.
I've known Jason for years through helping with the state exam, different LFNs coming out. He's a great resource. He's where all these things come from. So you got to put into him when you get one you don't like. But he again is a great resource. He also was an elected official at one point somewhere on Ocean County, correct?
Yes, Seaside Park as councilman.
Seaside Park. So again, but Jason's been a wealth of knowledge and a good resource for all of us for many years now. So with that said, did you want to read his bio? Is there anything else you want to add?
No, I think we're good to go.
All right.
When you get the right John Reinhardt stamp of approval, then you don't need to read any more of anybody else's bio. So good.
I'm honored. Thank you, John, for the kind words.
Anytime, Jason.
So before, John, were you going to talk about the Transparency Act before, or did you want me to just start
go
jumping
right
into 5:30?
I think this is going to take up a lot of time, so I want to get to this, and then if we have time, maybe we'll circle back. But
Okay. So thank you, everyone. It's an honor being here today. As far as NJAC 5:30, Chapter 30 is the local finance boards. There's a number of chapters of regulations that either local finance board or the division has promulgated over the years. 5:30 contains a number of regulations on a number of different areas related to budgeting, accounting procedures, audits. In the local finance notice, which just was issued yesterday, 2023-7, it goes into a summary of what the various chapters are, and you'll see that in the PowerPoint in a moment. But as far as, and again, it covers a myriad number of areas. And we have, according to the Administrative Procedures Act, generally speaking, a chapter has to be regulations, a corpus of regulations being a chapter, have to be readopted every 7 years, or otherwise they expire. And they could be readopted as is with no change, or readopted with non-substantive changes or substantive changes that require further public comment. As you may well have seen, there are a number of significant changes that and codifications of existing guidance that do require a public comment period. We are in that comment period now, which expires on April 22nd. So one of the reasons we're kind of out there with the local finance notice is to kind of help break down as efficiently as possible what those key changes are, and to point folks into the direction of, okay, here's what may be relevant to your particular space. John, do you have anything to add before?
no, let's get to it. Yeah.
Okay.
I've got no questions that are popping up either, so we're good so far.
Okay, Katie, do you have the PowerPoint?
Oops, sorry. Yeah. Yep. I can share it. Just give me one moment. Sorry, it's just opening up.
You know, while Katie does, want to say with Jason helping out with this today, it's a huge help because, you know, coming into this, I was focused on a few of these sub chapters, but you know, Jason has done presentations on this, and couldn't have asked for a better speaker to help me out with this one today. So thanks again, Jason.
So Jason had the unfortunate pleasure of bumping into me last Friday, on which I said, "Hey, Jason, you're the expert on this. Would you mind participating?" And he said, "Sure."
Absolutely. And again, thank you for having me today. As you can see, the local finance board approved the notice of proposal at its January 11th meeting. This was published in the New Jersey Register on February 21st. You see the citation there. Written comments are due by April 22nd, either through email, you have the subject heading, or by regular mail to the executive secretary of a local finance board. So as we go to the next slide, the next couple slides here, basically a summary of what each of the 18 subchapters of Chapter 30 contain. You have your general provisions, and go so on and so forth. You have accounting, subchapters 1, 5, 9, 9A, et cetera, include regulations relevant to all local units. Subchapter 9A is also relevant to boards of ed and charter schools. And then you have a number of subchapters that pertain to just municipalities and counties. Subchapter 6 is, as proposed for readoption, would also apply to joint meetings, which you'll see now referenced as regional service agencies due to a 2019 statutory change in the local fiscal affairs law and the shared services law. You see subchapters 7, 10, and 13 apply to municipalities. The LoSAP subchapter, of course, applies to municipalities and fire districts. And the board proposes readopting subchapters 11, 12, 14, and 18 without change. Subchapter 18 deals with municipal and county charitable funds. I don't see the board revisiting that anytime in the near future. Subchapter 11, which deals with open-end contracts and change orders. There really wasn't enough runway to address that in this readoption. As some of you may be aware, we have begun discussions with various stakeholders regarding needed updates to the change order regulations. But of course, given we had the pandemic, kind of sidetracked that effort a bit. But now that the design build law is in place and those regulations have been adopted by the division, we anticipate in the very near future getting back to that and including a number of needed updates to our change order regulations, including factoring in for design build. So, and again, subchapter 14 being LoSAP. So subchapters 1 and 2, you have subchapter 1, a key change there is to updating our realized revenue report regulation to standardize what's being asked if the division or the board asks for a realized revenue report. Again, detailed to list for each revenue, the budgeted amount, percent realized, and the amount not realized. This is probably something not many of you on the call have encountered very much, but we do periodically ask for this, such as if there's a municipality under transitional aid, or if there's additional information that may be required by the local finance board. And subchapter 2, which is deals with our local bond law regulations. New rule 5:30-2.7 addresses the useful life determinations by the director where none are otherwise specified for a capital improvement under the local bond law. This implements 40A:2-22.1. This was the subject of a notice of pre-proposal that was published back in 2019, circulated amongst various bond council and finance communities, as well as the league and others. This is another one where the kind of pandemic kind of sidetracked that a little bit, but with this chapter readoption gave us the opportunity to present the rule text. So on to the next slide, goes into a little further detail into what that entails. So for any capital improvement or property with a useful life of at least 5 years, which is of course the minimum for bonding under local bond law, that is not included under 2-22. Municipality or county may request that the DLGS director determine a period of usefulness for the particular item, provided that there's no law that expressly prohibits the authorization of obligations for that purpose. Now, any request of the director, that proposed regulation specifies what needs to be included, including identifying the particular item that's subject to the request, the useful life determination that's being requested, such as, okay, we're requesting a determination of 10 years. Again, it can be no more than 15 years. a certification from an engineer or architect or another appropriate professional that is in fact the appropriate useful life. State whether the particular financing would require local finance board approval, and whatever other information may be required by the director. Now, in our next slide, you'll see once the director issues a period of usefulness determination, the director, the proposed rule, the director may make the determination applicable to uniformly to all municipalities and counties upon the publication of a notice in the New Jersey Register. If it has been published in the Register as a public notice, a municipality or county may only submit a request for a determination on that item if it's readily and clearly distinguishable in some fashion from the published determination. So on to the next slide. Subchapter 3, new rule 5:30-3.7 and amendments to 3.1 and 3.3 codify the guidance of local finance notice 2017-25 pertaining to the county entity budget request cap. There are no changes here, but it codifies the guidance that we put in that local finance notice pertaining to how the otherwise known as the constitutional officer cap, that the various prosecutor, county sheriff, and so on and so forth elections. The budget requests that they present to the county commissioners, the county governing body, at which point that it can't exceed, their budget request cannot exceed an increase of 2% without the approval of the county commissioners. So again, if you're, again, our local finance notice, what's in place now, that isn't changing. That process is now being codified in regulation. With 5:30-3.3, looking at amendments that clarify that in the case of dedications by rider that don't require prior director approval, the division must still get a copy of the adopted resolution. It also allows a copy to a municipality to establish, that's in a UEZ, to establish without direct approval dedication by rider for a UEZ trust fund, implements a recently enacted law that requires a UEZ municipality to hold in a trust UEZ funds that are received from the state treasurer. There's also a cross-reference to 5:30-9.9 pertaining to a trust fund for convenience fees or surcharges that are charged for electronic receipt transactions, such as an ACH or a credit card, that are to be deposited in a dedicated trust fund titled electronic receipt fees. So as far as in the next slide, going on further, 5:30-3.8, we've already started implementing this in practice, but this would codify that the user-friendly budget, to be clear, there still needs to be an introduced version as well as an adopted version, but the introduced version does not need to be submitted to the division. Again, it still needs to be provided for the benefit of the public, but we don't need to get a copy of that. For the accumulated absence liability, it would require a municipality to list as the final day of the prior budget year, the gross number of days of accumulated absences and the dollar value of those absence days as of that accumulated absence as of the final day of the prior budget year, broken down by bargaining unit in the case of unionized employees and individual position in the case of non-unionized employees. We had required the individual's name, but in the being conscious of greater privacy initiatives, this isn't obviously to implement Daniel's law, but kind of in that zeitgeist, we would be going by position rather than singling out an individual right on the public document. Again, if these are non-aligned employees, where you have employees holding more than one position, it would be the sum of all their positions. So each individual position, regardless of whether or not they're part of the bargaining unit, you'd also have to indicate for which individual serving therein is subject to the restrictions on accumulated absence compensation and or accumulation pursuant to law. In other words, whether or not they're under the 2007 law, chapter 2007, chapter 92, regarding certain higher level executive positions, the restrictions on, in other words, the cap on accumulated absence and the restrictions on vacation carryover, as well as the 2010 law, 2010 Chapter 3, pertaining to employees that were hired on or after May 21st, 2010. So you're looking at a codification of 2007 or 2008 local finance notice. I don't have the site right in front of me, but I think we discussed that a little further on. So if you're looking to refer to that. Now on to the next slide. New rule 5:30-3.12 would require that if you have a municipality that's looking to sell its water, wastewater, or other municipally owned utility service, like it has an electric utility, for instance. We're not talking about golf course or an ice rink utility or a marina utility. That's not really what's being talked about here. To another entity, it's by and large water and sewer. So if you have a water sewer utility and you're looking to sell it to another entity, if you're starting that process, the division needs a copy of that resolution and or ordinance that are authorizing the sale of a long-term lease. And if you have a resolution that's authorizing the issuance of a bid or request for proposals, we need that within 5 days of adoption. Now under 5:30-3.13, we would also need a municipality or county that's undertaking a referendum to deal with a levy cap question, such as an increase in the municipal or county levy cap, or an open space referendum, or it's a culture levy referendum, and alteration to the public library tax, and as well as a referendum on municipal appropriations cap. We would need a copy of that resolution or ordinance within 5 days of adoption, along with a copy of the results of that referendum. So it's something I think we ask for routinely, but it's something that we codified now just to make it clear that as a matter of course, we need those documents. So on to the next slide. On subchapter 4, by the way, Katie, if I need to speed up for time, just let me know.
I think you're
know
good.
this is
Yeah.
quite dense.
Yeah.
So
No.
it's I'm sorry. Okay. For subchapter 4, this implements certain provisions of the Water Quality Accountability Act, in other words, section 7(8) of 2021, chapter 184, that require any municipality having its own water system to prepare and adopt a capital budget and capital program annually. In other words, there's no exception if you haven't filed one within 3 years. It has to identify the water infrastructure improvements that are listed in the WQAA annual capital improvement report that's submitted to DEP. Division approval to adopt the municipal budget may be withheld for the failure of a capital budget to identify the improvements that are in the capital improvement report. It would not, just to be clear, it would not require the capital budget or program to extend beyond the current 3-year, 6-year minimum, depending on your level of population. In the case of municipalities. Now, as far as any of you are familiar with the capital improvement report, there's a listing, it's based on your water utility, your water systems asset management plan. If you're a municipality with its own water system, you would list the improvements on the form, and they're divided into 2 categories: short-term, 1 to 3 year, or long-term, 4 to 10 year. As you know, as you may kind of recognize, in order to fully implement these regulations, we would need an amendment to the capital improvement report to kind of include a medium term, 3 to 6 years, so as to allow our budget examiners to track what the improvement is to the capital budget. Assuming the board adopts this regulation, we also anticipate kind of really emphasizing the local finance notice that the verbiage, the terminology that's used for the capital improvement in the capital improvement report needs to be mirrored on the capital budget, so there's a clear one-to-one relationship. So if the budget examiner does not see that on the capital budget, they're going to give you a call or kick that back and say, hey, listen, what's in your capital improvement report needs to be cross-referenced on the capital budget. So that's something, and again, that's assuming we can iron that out. on our side with the capital improvement report, it's really going to be incumbent on the CFOs and the municipalities to really make sure that those two documents track for our purposes. So on to the next slide. Subchapter 5, it really deletes some obsolete language that really allowed municipalities and counties to, in lieu of an encumbrance counting system, sequentially number all purchases on pre-printed multiple copy purchase orders. That was kind of a legacy that really is obsolete, so we propose to take that language out. Local authorities and fire districts, given that they tend to be less complex operations for the most part, there's not a requirement that they maintain an encumbrance accounting system, but this update would require them to maintain a record of all open contracts, including all open purchase orders, and for purchases not requiring formal action of the Board of Commissioners, for the individual approving the contract to consult the list of open contracts and determining whether there are sufficient uncommitted appropriations to provide for the payment. So those particular updates kind of clarify that point in subchapter 5. Now, 5:30-5.7 would be amended to require that all local units, including authorities and fire districts, maintain a general ledger for all funds instead of just the current fund, which is what's currently stated in our local finance notice CFO 2013-14. Otherwise, 5.7 as proposed would codify that guidance in that local finance notice concerning the maintenance of general ledger accounting systems. It goes into further detail, specificity in the rule proposal, with the exception that all local units, including authorities and fire districts, would now be required to post the totals for all funds to the general ledger on at least a monthly basis. Now, our current guidance states that funds with minimal complexity or few transactions may be done only at the end of the fiscal year. So in the interest of strengthening oversight and increasing consistency, we've extended that monthly posting requirement to all local units and in terms of all funds. So on to the next slide. Subchapter 6. NJAC 5:30-6.1 would apply the accounting and auditing requirements that are currently in place for municipalities and counties, would expressly apply them to joint meetings, aka regional service agencies. It also codifies kind of something we've been implementing over the past couple of years in the interest of helping move along municipal and county audits. So it would state that municipal and county and joint meeting audits may list the most recent available GASB 68 and 75 information rather than wait for the most current version as entities that report under GAAP must do. Updates reference, I'm sorry.
No. I mean, that one's huge. It's huge from our perspective, and it's huge from our clients, our municipal clients, because if you have to wait for that information to become available, you're pushing your year-end, not your year-end deadline, but your audit deadline way out. I mean, I know we dabble in the school business world as well, and school districts are now pushed out into March to get their audits out because we're waiting for that most current information from the Division of Pension. So this one's big. If we put this in stone here and we say use your most recent information, then there's really no reason to push out the audit deadlines for municipalities. We could stay on track with this, and that's one of the biggest takeaways. Obviously, you can see the sections that I zoomed in on when this came out, but that's huge for all of us.
Right. And again, since it only was required to be in the notes, unlike with GAAP, it was something that, given in recent years, the challenges in getting timely information, it's something the board felt they needed to propose as a matter and kind of really set that in stone. Subchapter 6 in Amendment 6.1 also codifies the current process for submitting an audit to the division. Also codifies the process for publishing for the governing body to publish a synopsis of their audit and the corrective action plan, including the governing body's responsibility to adopt a summary schedule of audit findings, and with respect to a single audit, a separate corrective action plan and a summary schedule of prior audit findings. This had been in 1997 local finance notice, a couple other LFNs. So, the board felt there was really a need to codify that in regulation in a central location for purpose of more consistency in terms of compliance. It also codifies the process for an auditor to notify the division upon the discovery of fraud or illegal acts, including what's in Appendix A to the notice of proposed readoption, the form of the confidential report. As you may know, those of you who are familiar with 5:31, our local authorities regulations, that's already codified there. This would create that similar codification in subchapter 6 and 6.1. So in subchapter 7, it amends proposed amendment to our this is our local budget examination subchapter. Amends 5:30-7.4 to classify following municipalities as ineligible for local budget examination. This is really largely codification. A number of these exist now, but there are some changes. One of these, of course, is municipalities under transitional aid. They were never really under local review, but it just updates the updates the regulatory reference. As far as compliance goes, municipalities that fail to submit to the division the user-friendly budget that corresponds to their previous year's adopted budget. So if you're lagging, if your municipality is lagging on that, if you otherwise would be eligible for local exam, you would not be until you get that if you submit that, unless you submit that through Fast to Us. So that's really kind of an extra stick, so to speak, to get user-friendly budgets that correspond with the adopting budgets in on time. They're supposed to be submitted with the corresponding overall adopted budget. If during or the current or prior fiscal year, an individual who, if you have a temporary CFO, you're not going to be eligible for local exam. And the same thing, we've started to implement it this year, kind of under our omnibus exception if the director feels that in the interest of fiscal integrity, the municipality needs to be taken out of local review. As Bud had mentioned earlier, if during the current or prior fiscal year, you have a private entity that is or was temporarily fulfilling the duties of a CMFO, they will be taken out of local exam if they would have otherwise have been eligible. Now, municipalities where in the prior fiscal year, voters approved the sale of a water source system, those will be taken out, as well as those that are completed the approval process under the Water Infrastructure Protection Act, the sale of a water source system, to better allow us to confirm that the statutorily permitted use of proceeds under those laws are in fact being followed. Now, just to remind folks quickly, for those, there have been a few municipalities in recent years that have sold their water source systems via referendum. That's 40:62. It needs to be used toward paying off your debt proceeds for your system, then go toward your general debt. And to the extent the municipality has wiped out all of its debt, then it can be used for general purposes. So that's really just a friendly reminder. Now to the next slide.
Hey, Jason, I'm going to chime in and do our first polling question before we move
Sure.
on. Okay, so this question is, as a CFO or other participating official, does your municipality or authority own its own water systems? And I'll leave it open for a moment and then share the results.
Actually, I'd like to take the time to remind everybody it is a roundtable, so we look forward to your comments coming in. You guys are awful quiet on this Sunday morning or Friday morning. Good thing it's not Sunday morning. So if you could just type in some questions, add to the discussion, that'd be great.
All right. Okay, so looks like again, we're about half and half yes, no, and then some others. Thanks.
Okay, so subchapter 8, it updates regulations concerning surety bond coverage provisions. to conform with the reference to the 2013 law that allowed blanket bond coverage for CFOs, tax collectors, municipal court judges and administrators, including through JIF. 8.2, which recommends currently a surety bond schedule, minimum surety bond schedule for chief financial officers, would make that schedule a mandatory minimum. The exposure index from which the bond amount is calculated is at least 10% of the total revenues of the local unit. It also would amend the exposure index for CFOs and tax collectors to include additional categories of revenue handled by those officials, such as if there's a local cannabis tax, a pilot revenue. So those hotel motel tax. So those items that weren't really expressly included in the reg are now brought in. Tax collectors clarifies the term tax duplicate refers to all tax levies. I'm going to get on the next slide. You're going to see what the I don't need to go there just yet, but you're going to see what the exact schedule is for ease of reference. Now, new rule 5:30-8.6 would establish a regulatory framework for the hiring of off-duty law enforcement, including the adoption of a formal policy by the municipality or county concerning the employment of off-duty law enforcement, off-duty employment, defining limiting what are permissible administrative fees. To be clear, this regulation does not cap or limit what a police officer can earn as a part of what their off-duty employment is. So if their collective bargaining agreement allows them to earn $75 an hour, then that's what it is. This regulation does not, the proposed new rule does not change that. What it does, it largely codifies LFN CFO 2000-14, but it goes further in that it defines what may be charged as administrative, what may be charged toward personnel, what may be charged as automotive fee. So if you have if you're charging for vehicle usage, you're largely limited to what the FEMA Stafford Act limits are, unless there is a written justification that's provided. Equipment and other are, in other words, if it's not permitted under the other categories, you can't just put it under another omnibus category. But if there are unique equipment expenses that are required, or let's just say horses are being used for kind of an off-duty event, that's something that would probably be under other. 5:30-8.8 would implement annual reporting for long-term pilots that are separate from the user-friendly budget. This regulation is now in place, but it's never been implemented. Currently, it specifies long-term pilot reporting that according to the regulation, will be required to be part of the AFS, and we will be required to be what's reflected in the annual audit. This proposed amendment would take it out of the AFS, and by in turn implementing the law, implementing the regulation, but would take it out of the AFS, but it would require this report to be submitted simultaneously with the AFS. The deadline would be the same, but it would no longer be part of the AFS. And again, this has not been implemented. We've heard over the years that this perhaps really shouldn't be part of the AFS. So as a means of compromise, the board has looked at it and said, you know what, let's take it out, but it's not something that really should be audited or part of the AFS, but it should be done. It should be submitted simultaneously.
Jason,
and new rule 5: I'm sorry.
Jason, is there a form that you guys have established for this reporting?
We have not, but we will be providing a form. It wouldn't be promulgated by reg, but the director would be setting forth a form, and it would be submitted through FAST.
Thank you.
Okay. Now, similarly with 5:30-8.11, this establishes required content procedures for annual stormwater utility reporting that implements 48:26B-11. Now, there hasn't been a municipality or county that has established a stormwater utility, either as standalone as part of an existing water sewer utility. If they do, DLGS is required to promulgate a annual report detailing various pieces of information, such as what percentage of appropriations are geared toward infrastructure improvements, education, outreach, so on and so forth. It's kind of comprehensive, so I didn't include that here in the PowerPoint. But again, we don't have a, there's no appendix that contains the form of the actual report. That's something that would be promulgated by the division, assuming the board adopts this rule, and we would provide as part of a local finance notice.
Hey, Jason, I had one question come up while you were going through this here. If a municipality contracts with a firm for services but has an appointed acting CFO who's not certified, does that entity have to go through the state exam each period? It says the proposed change isn't clear if it's for services that are handled by a CFO or if it's for a firm appointed acting as a CFO for a period of time. So my initial reaction would be yes, that would be a state exam. But your thoughts on that?
Yes. So really, I mean, a private entity that's conducting the duties of a CFO, because you may have someone that's nominally appointed, like they get a nominal, or for CFOs, a nominal salary, but they're employed by a firm. They would still be considered a private entity temporarily conducting the duties. But in either instance, private entity or a temporary CFO, meaning unlicensed, meaning they're acting for like 1 of 3 years, then yes, they would be subject to state exam, correct. So as we go to the next slide, here is our is the exposure index. That would be the bond amount, exposure index and bond amount. What's now suggested would be proposed to be a mandatory minimum. So you see that there, and you'll see that further in the. It doesn't say that it doesn't specify it in the actual, because the amounts are not changing. It doesn't include it in the actual notice of proposal, but it is under our current regulations under 5:30-8.2. So you see the schedule right there that is proposed to be made mandatory.
And then a question that came up with that could we confirm that now CFOs also need to get bonded like tax collectors did previously?
Yes, this would be a requirement now. Yes, under the proposed rule. Yes.
Thank you.
So subchapters 9 and 9A, not a lot there, but it would just updates to reflect recent amendments to the Government Electronic Payment Acceptance Act. There's a polling question on this that I'm sure Katie will get to in a moment. Internet-based, in other words, use of MoneyGram or Western Union is permitted for intake of payment systems, so long as GUDPA requirements are continuing to be followed. In other words, those funds need to be deposited into a GUDPA protected account from whoever, either online or in person, is taking the payment. Subchapter 9A is just kind of clarifying the language of the relationship between the claimant cert and the what's actually a separate cert being for the receipt of goods or services, and the requirement that local finance board approval local finance board regulation is required in order for advance payment to be made in advance of the receipt of goods or services. So it's really clarifying that language there. So, okay, if we're not going there, whenever the next polling question is, just kind of hint, has to do with the subchapter 9.
Yeah, I can launch that one now.
Okay.
Oops. Okay. So the next question is, does your local unit allow for individuals to make payments through an alternate in-person funds transfer mechanism such as Western Union or MoneyGram? Give it another minute. Again, make sure you get your responses in for the credit. All right, looks like we got mostly no's, but some yeses. There are the results. Great, thank you.
Yeah, we did issue a local finance notice on this. I don't remember the exact site, I believe in 2021 or 2022 for on this subject, probably 2022. So take a look at our local finance notice. By the way, we recently updated our spreadsheet of local finance notices. They don't have the last few that have been issued, but they're updated up to probably the fourth one issued in 2023. So if you see that spreadsheet, go on our local finance notices webpage, that has been updated. So just a quick reminder there. Subchapter 10, what had been municipal port authorities is being recodified as 5:31 chapter 9, moved to the authorities chapter. And subchapter 10 is now contains some regulations pertaining to municipalities under state supervision. So for purpose of municipalities' eligibility to be placed under state supervision, the default trigger on is being clarified with respect to if you have a municipal debt obligation that's failed to be paid for whatever reason, including failure to make funds on hand available for paying the debt service. This regulation clarifies that that would constitute a default for purposes of one of the triggers for state supervision. It also further defines the director's authority to order a municipality under state supervision to authorize or make disbursements in accordance with the adopted budget or any temporary or emergency appropriations, and make such disbursements directly on behalf of the municipality if the municipality fails to do so. It would also codify the authority granted to a fiscal control officer if one is appointed by the board to oversee a municipality under state supervision, along with the board's authority to appoint a fiscal control officer on behalf of the municipality should they fail to do so, and procedures for terminating a fiscal control officer. So skipping up to subchapter 15, which deals with our accumulated absence liability and financing. As you may know, the recent comptroller's report pertaining to a particular municipality, there's been a number of webinars and seminars from that report issued last year, and in taking a look at gave us opportunity with this chapter readoption to take a look at this subchapter and see what areas we perhaps need to augment in our code. And it does contain a number of changes, one of which we already indicated in chapter 3 or subchapter 3. It'll make updates. A lot of this is really codifying what's in existing law, but it's interspersed in various local finance notices. It would update the code to reflect various statutes pertaining to accumulated absence liability, codifying the guidance in LFN 2008-10. It would apply the provisions of subchapter 15 to joint meetings, aka regional service agencies. It would also amend 5:30-15.3 to require a more detailed breakdown of accumulated absence liability on the introduced and adopted budget. The accumulated absence liability page would still for municipalities would still only need to be included on the user-friendly budget section of the introduced and adopted budget, but that page would need to be submitted to the auditor. So it's not part of the action in counties and authorities. It's integrated as part of the integral budget document. In the case of municipalities, still be part of the user-friendly budget, but that particular page need to be submitted to the auditor. It would amend 15.4 to require documentation of employee's hire date and the amount of the accrued absence time before compensation can be paid out to an employee. 15.4 contains the requisite documentation that the governing body needs in order as a prerequisite to approval of the payout. 15.10 would require, it's a new rule that would require as part of the annual audit, the auditor to undertake sample testing of the local unit's compensated absence liability, if any, using the following procedures: inspecting the budget's accumulated absence data and employee personnel records to confirm whether those records support the number of hours or days of accumulated absence reported for the employee, determine whether the employee is subject to the provisions of 2007 Chapter 92 or 2010 Chapter 3 pertaining to accumulated or compensated absence. Confirm that the dollar value of compensated absence recorded for that employee is authorized by labor contract, individual employment agreement, or an ordinance or resolution as appropriate to the local unit. If the employee are subject to the 2007 and 2010 laws, confirm that the recorded dollar value does not exceed the amount authorized pursuant to. So
Jason.
subchapters 16 and 17, this is really the last substance. It would add the following officials to the list of those that must register for GovConnect: business administrators and municipal managers. County, they already have a GovConnect category, but this will make it mandatory. County administrators and managers, individuals appointed by the governing body to serve as QPA. We have a procurement official subcategory in GovConnect, along with CPWM, certified public works managers. This would make it mandatory for them to enroll. Subchapter 17, again, not too much in the way of changes, just really clarification that clarification on the language that no local unit or school district may utilize a third-party disbursement service for a purpose that's not expressly authorized by the board. The requirement's there now, but the language is made more clear. We would also update 17.5 and 17.6 to reference the latest auditing attestation standard for third-party disbursement service financial controls, updating it to 18. I think the final slide is just resources and comments. Local Finance Notice 2023-7 contains a lot of this, what we've presented today on the PowerPoint. So by all means, take a look there. The proposed chapter readoption with amendments and new rules is also on our rules and regulations webpage, both in what's published, the form that's published on the register, as well as a Word doc that's a little bit easier to read. And our existing regulations and for subchapter 30 are also contained on our, are also posted on our rules and regulations webpage. By all means, if you have a comment, positive, negative, or different, send those comments in writing, either by email to us or in as hard copy. Again, we encourage everyone in the regulated community to kind of take a close look at these, at the notice of proposed readoption, and to, even if there are no changes proposed to a particular subchapter, if you think there should be a particular change, or if you have particular concern, definitely, we welcome those comments, and they're due by April 22nd. John, did you have anything else?
There was one more question that came up, going back to getting bonded. Is this something that CFOs are able to initiate, or is this still just a function of the municipal clerk going through the process and getting bonded, or doing the bonding?
I think it depends on how you operate. Every town's gonna be a little different. Who's getting the bonds right now for the collector? It's the same location.
Okay.
Hey, Jason, I had a quick question. If you were to characterize the changes that are proposed, how would you characterize them in general? And are there any specific ones that you would highlight as being the most important?
Thank you, Bud. That's a very good question. A lot of these are codification of existing guidance that haven't been changed, but kind of the reason why we want people to take a close look at it is even where we've codified certain provisions, we have made certain changes and kind of augmented what's currently in guidance. A good example being in for the off-duty law enforcement, 5 Code 30-8.6. But there are a variety of new rules. So I think maybe kind of in a nutshell, significant portions are codifications or clarifications, but there are various substantive changes that we would kind of want to point people to. Kind of a particular importance, subchapter 3, subchapter 6 pertaining to the audit and accounting standards. Subchapter 8, where you have, again, the off-duty law enforcement, the pilot report, and the stormwater utility report. as well as for accumulated absence liability in 5:30-15.
Thank you.
We had one last poll I'll launch just before we wrap this topic up. So this question is, does your local unit currently maintain a general ledger for all funds?
And then after this, there's two questions that just popped up, Jason, so I'll get those out after the poll is done.
Let me make sure everyone gets the response in. And it looks like we got mostly yeses.
Okay.
Thanks,
So,
everyone.
so if a CFO is also the tax collector, what would the amount of the bond for the tax collector, would the bond of the amount for the tax collector be sufficient to cover the CFO's portion? Or should this be an increased bond to cover the two positions as though they were separate?
You know, that's a good question. We currently don't speak to that in the regulation. That's something that we could probably either clarify in a local finance notice or perhaps, clarify in the regulation. But I don't, that's something we'd have to take a further look at.
Okay.
Especially since it's not uncommon.
Mhm. And then the final one is in my GovConnect. The GovConnect news has not been updated since August of 2022. Does anyone know why? I was going to send out an email to GovConnect, but they mentioned they were backlogged and it's not an emergency.
Okay. Oh, that's news to me. I'll double check into that.
Okay.
Looks like that's it for now.
Yep.
You want me to introduce the next group of speakers?
Sure.
All right, so next up, we have Bob Beinfield and Michelle Lukopoulos. So we're going to talk about the SEC Rule 15C212 for the small issuer. Those of you that have not encountered this yet, it's going to be a royal pain as you're about to hear from Bob and Michelle. So a little bit about Bob. If you've had Bob as your bond counsel, then you know that you get the best Christmas cards ever. And I saved every one of them that he's ever sent me because they just crack you up. So Bob serves as bond counsel, underwriters counsel, disclosure counsel, and trustees counsel. His practice for more than 35 years has included a variety of financings for many types of governmental issuers in New Jersey, including the state itself and many statewide issuers, counties, municipalities, school districts, sewage authorities, municipal and county utilities authorities, county improvement authorities. I'm going to stop there because he does it all. And Bob, interestingly enough, was the bond counsel for the Rockaway Valley Regional Sewage Authority. And I found one of his really old opinion letters hanging on the wall one day, which was fantastic. So of course I had to call him. Next up, who's going to be contributing here is Michelle Lukopoulos. Michelle has the burden of working closely with Bob. And she has been with Hawkins, Delafield, and Wood for 20 years, primarily practicing in the firm's New Jersey General Obligation Group, serving as bond counsel, trustees counsels, underwriters counsel, and disclosure counsel. During her tenure, she has also represented the state agencies, dozens of municipalities and authorities in connection with the issuance of bonds and notes, securities law issues, and tax law issues and compliance issues. With that said, there's Bob and Michelle.
Thanks, John. I'll make sure I'm unmuted and, please, you can lose that opinion from the wall, but do keep the cards. They're much better than the opinion, that's for sure. What we're going to talk about for a little in particular is there's been some changes in our, really the focus is going to be the notes, issuing notes, and whether or not we use an official statement for issuing notes. Some of you, and I'll be very curious, some of the polling questions to see what the practice is out there and what you've done in the past. Some of you, particularly if you're a larger municipality and issue a sizable note, you may have been doing official statements for a while with your notes. Bonds, as we'll talk about, almost you'll never see a bond issue, almost never, without an official statement. So this is really geared to notes where we've really had the option. The marketplace has given us, you and your team, an option of when you go out for your note issues, whether or not you're going to produce a disclosure statement. We'll talk a little bit about what an official statement is. There was an enforcement action by the federal regulators, which we'll discuss last year, last September, that really made it a little bit more difficult for underwriters to purchase our notes unless they also have an official statement. So that has led to a little bit of a different dynamic in our marketplace, in your marketplace, when you go to sell your bonds and notes. It doesn't necessarily change what you will do or what you have been doing, but it very well may, depending on your particular situation. So this stuff is good to know about. It's good to know about not a week or two before you're doing your note rollover, but a month or two. So you can make, if you need to make an adjustment, you can plan with your professional team to do that. And, you know, Michelle and I have been some of you may have already heard what we're going to say. Hopefully we're a little bit consistent as we've been grappling with this for the last, 4 or 5 months. And it'll be something that you will be seeing or doing if you haven't had yet. So with that, thank you, Katie. The overview really is, let's set the groundwork first. What is an official statement? What is it and why are we doing it? Do we have to do it? Is it a requirement, and where does it come from? And if we haven't done it, why haven't we done it? Why haven't you done it would have been, you have some exceptions to producing an official statement. So we'll go over those exceptions. There are not many, and they're pretty simple, actually. There are only 4 of them. And one of those exceptions was kind of squeezed last September by the federal regulators. So it is not as friendly to the underwriters. So that's what's changed. So that exception isn't as robust as it used to be, which has affected the next thing that we're going to talk about, which would be the things we think about when we decide whether or not we're going to use an official statement. Again, this is for our note issues, something that for many of us, you never really needed to think about this in the past. Now it at least has to be something that you consider, and the factors in determining whether you want to produce one, the weighting of those factors has adjusted a bit and is not the same as it was last year at this time. Then want to take a quick look at, and importantly, of what actually has happened in the marketplace. We're going to take a look at some of the sales. We're going to look at some of the results. We're going to see what the changes may be and may have been, and how that could inform what you and your team end up deciding to do. Lastly, we'll try to bring it home with, what does it all mean for me? And how do I figure out what my options are and what I should do or think about doing? So I think what we're going to do is I'm going to hand it off to Michelle for a couple, but I'm actually wondering, Katie, is it too early? Is it too easy to do a polling question now? Because our first polling question, I'm actually very curious about the answer to it, to see just to take a look and see what the audience generally is doing and has been doing, and then we'll move on.
Yes. Yep. The first question we had is about if they're planning to issue bond anticipation notes. Is that the one? Okay, perfect.
Perfect.
Okay, so I'm going to go ahead and launch the first question. Are you planning to issue bond anticipation notes over $1 million this year? Give it a minute and then share results.
Thank you.
Right.
And if we get a lot of not applicables, we can scratch the next slides, but let's see what happens.
It looks like luckily we're pretty split again. Yes, some yeses, some nos.
Okay, so this is going to be particularly relevant for those with the yeses. For those with the nos, maybe it's not this year, maybe it's in the future sometime. And all just a little bit of a more general then of what goes on in the borrowing and in the debt market. So with that, I think I'll hand to Michelle to start it off.
Hi, everyone. I see a lot of familiar faces on the participant list, so it's good to see your names. And so knowing a lot of people who are on here, I know that most of you are familiar with what an official statement is. But, you know, I mean, it's good to go back to basics sometimes. So I'm going to give you a primer. I'm going to do the 101 version of this topic, and then Bob will go on into the more nuanced second level class. So an official statement basically is the document that a municipality would put together when they are going to be selling their bonds and notes. And it allows the investors, the underwriters, the investors, the public to get an idea of who you are and why you're selling your securities. So there are three basic functions of an official statement. The first is that it provides a description of what the transaction is. It helps, describe, is this a general obligation security? Is it a revenue bond? Is it, what is the purpose for the note? The second function of an official statement is it helps the underwriters market or you, depending on whether it's a competitive or negotiated sale, it helps market the securities. And it allows, like I said earlier, it allows the investors to make informed decisions whether they want to purchase the note. And then the final basic function is that it discloses material information about you, about the municipality. And the official statement, if you haven't done one in a long time, it may seem like it's a big, daunting task, but generally it's, has a very similar layout throughout the industry. And the basic contents, first you have the cover page, which summarizes the issue. It has your name, it has the amount of the security, the interest rate. It has, what your rating is, and it's a short summary. And then within the body of the official statement, the first typical, part of it is there's an introduction of what the issue is. There's a description of the security. When is it coming due? What are the interest rates? What are the maturities, the denominations? It sets forth the redemption provisions. It says, these bonds are either they're not callable or, they're callable in X amount of years. It has the purpose of the issue. So what we'll do is, typically you'll list the ordinances that you're borrowing on and a short description of what those ordinances are for, and then the amounts per ordinance. And then it describes what the source of repayment for the security is. So that's, your deal specific information that's contained in the body of the official statement. And then a large portion of it, the remainder of it is very often boilerplate. It has a description of the bond law, the description of the budget law. It has a bankruptcy provision. It has, you know, your the litigation or no litigation section, our tax language, the secondary market disclosure section, which, you know, sets forth what the obligations are for a continuing disclosure once you issue the notes. And then it'll discuss, you know, the rating, who the underwriter is, and so that's the body of the official statement. And then typically there are 3 appendices, sometimes 4. The first one is information about the municipality. You know, it's describes in a write-up information about the town, and then provides the operating data, you know, largest taxpayers, property taxes, you know, some financial information. And that would be the source of whatever continuing disclosure obligations that you might have in the future going forward. So that's that's where you have the opportunity to kind of market yourself and describe about your town and why investors, you know, should be interested in purchasing your securities. And then the second appendix would be your audited financial statements. And depending on the time of year when you issue bonds, if you don't have current audited financial statements and it's been a while since, you know, the last audit has come out, sometimes people will include unaudited information as well. And then the final exhibit typically is a form of our opinion. So, you know, aside from deal specific information, you know, I would say like a good, you know, not counting your appendices, you know, a good portion of it is boilerplate information. So that's what the official statement is in a nutshell. The important thing to know is that the municipality is legally obligated to provide factual information. So whatever you're setting forth to the public, you are responsible. You are legally responsible to make sure that that is factual information and that you're not withholding or omitting any material information that the investors should know. The SEC can impose you know, legal liability against you if it's determined that you have made material misstatements or failed to make, you know, include material information. And just, I guess, the last point on this slide, the preliminary official statement is what is set forth to market the bonds. So that's issued before we sell. And that's essentially a final document. The only information in there that would be updated when we sell the bonds or notes would be the terms, you know, what the interest rate is and who purchased it, and, you know, any changes in the maturity schedule. So, but other than that, everything else should be unchanged between the preliminary official statement and the final. So Katie, I think we could go to the next slide. Okay. So why are you required to use an official statement? So this is, you know, the Securities and Exchange Commission has their whole purpose and why an official statement, broad stroke, is required is because the SEC is trying to protect investors. More, you know, more specifically, they want to protect like you and me, the general public investors, as opposed to, you know, the big, you know, underwriting banks. But they're looking out to protect people who are investing their money. So they want to make sure that you know, there's some there are guidelines. And while the SEC doesn't have any power to regulate governmental entities, the municipalities directly, the way that it's, the workaround is that they're regulating the underwriters and the brokers and dealers. So the underwriters are required to get other than, with the exceptions that Bob will discuss later there are several exceptions. Typically underwriters, broker dealers are required to obtain an official statement in connection with bonds and certain and notes too, but depending on the size of the notes. So an underwriter is required to receive this official statement. And this is, the obligation is under what is called Rule 15C212. The rule gives guidance about, what the contents that that I discussed earlier should be required. The broker dealers cannot underwrite a transaction without the issuer agreeing to comply with Rule 15C212. So essentially, the rule makes it unlawful for the underwriter to purchase the securities without the official statement. There is diligence required on the part of the underwriters. So they will often look at a preliminary official statement, and they might contact you or us or your financial advisors prior to the sale and ask for additional information. And they so they have a whole team, and it's gotten throughout the years they've become more I guess they're looking for more specific information. So the diligence on the part of the underwriters, because of certain actions by the SEC and within the past 10 years, they're looking to make sure that you've presented all of the information that you need to present. So I think let's see if I'm missing. So Bob will go over what the exceptions are for the bonds and the notes. I think that's it, Bob. I'll turn it over to you unless anybody just wanted to jump in. I doubt, like I said, I think most of you are fully aware of what the background is, but happy to answer any questions before turning it to Bob. Okay, Bob, all yours.
And it's great, Michelle. And key to what she just said there on that slide is it is unlawful for an underwriter to buy your notes. And it's key also that it's unlawful for the underwriter, not you. If you don't have an OS, that it's not your problem, so to speak, but it is illegal for the underwriter to purchase your notes without an official statement. Unless there's an exception. Case closed, that simple. So now we're going to look at the exceptions because many of you we have been utilizing the exceptions for forever in a very smooth market. We've been, so let me go through the exceptions and then we'll talk about them a little bit. Exception one, pretty simple, and there are just 4 of them, and the big one is going to come up after these 3, but exception 1 is if you're under, that's why the polling question had the $1 million inserted in it, because if you're under $1 million, you don't have to use an official statement. The SEC really has, I guess they kind of view it de minimis, and are not going to put folks, underwriters, through the trouble if it's less than $1 million, and maybe they really don't think that those are the types of securities that the underwriters will really buy. So that's exception number 1, under $1 million, not $1 million, million you're in, under $1 million you're out. Exception 2 to the underwriter requirement to get an OS is if the note matures in 9 months or less. Why? And authorized denoms of 100, but don't worry about that. That won't be an issue for any of us. But the why 9 months? I'm not sure why 9 months, but that's what they perhaps not randomly. That's what they inserted in this Rule 15C212. Would have been very nice if they said 12 months. We could have all lived with that nicely, but they put 9 months. So if you're doing your normal rollover of a note for a year, you can't avail yourself to this exception, and we'll be back to this exception maybe a little bit later when we talk about current market practice. Interestingly enough, this Rule 15C212, you're all very familiar with it, I'm sure, for continuing, those of you who have to do continuing disclosure. That is the culprit. Rule 15C212 had 2 main parts. One told the underwriter what we're talking about today, that they need to review official statements. And the second said, not only do they need to review official statements, but they also have to be sure that the issuer, you, has contracted to provide continuing disclosure. So for the last number of years, and this came in 30 years ago now, last number of years, we've had tons of seminars, and still do because they change it and amend it now and then, on the continuing disclosure element. Now we're going back to something even more fundamental, which is just the obligation of the underwriter to review an official statement. So that's number 2. Unfortunately, 9 months isn't a help unless we squeeze our note issue down to 9 months. Again, we'll talk about that later. Number 3 is useful for us. The SEC only has the power, as Michelle was saying, to regulate underwriters. They don't have the power to regulate deposit banks. They don't have the power to regulate municipalities. They don't have the power to regulate the New Jersey Mel, for example. So all these entities, if they buy your notes, there's no requirement, since they are not an underwriter, there's no requirement that they receive for the thought that if they don't, they're in violation of law. They have no requirement to receive, obtain, and review an official statement. So that's a third exception if the buyer is not an underwriter. So there we have 3. The action is all on the next slide, which is which is exception number 4. This is where everything is, and this is why we have a change in our market, and why we're talking a little about this today. Most notes that have gone out in the last number of years without an official statement of any size, because as the size of the notes gets up there, it's more difficult for the deposit banks to allocate capital, more difficult for the MEL to get involved. The MEL, as John was so instrumental in changing their regulations, which allowed the MEL to step in the beginning of 3 years ago with COVID, when nobody else would lend. The MEL was there to take our notes. Again, these, as the size of the note issues gets up there, what has been relied upon by the underwriter community is this exception number 4, which is called a limited offering exception. What that is, and I'll read the text, I think, in a minute to make sure I nail it and absolutely get it right. But this is, again, this is on the underwriter. This wasn't on you. And the SEC has the power to regulate and enforce, which they did, against the underwriter and not against you. So what the rule was that if there is, from the SEC's point of view, if the buyers of the note are kind of a limited number of people, they're not a lot of them, they're all sophisticated, they're all buying for investment purposes without an intent to resell the notes down the line to anybody else. The SEC kind of says, well, we're not so scared of this. This really doesn't sound like this is going to the general public. We don't have to worry that our prime mission is being disrupted, meaning the mission to protect the mom and pop, you and I type of investors. That was, the SEC says, I really don't have to worry about it. This isn't getting into the hands of the general public. So they have this exception. This exception still exists. So just to make sure I covered it here, let me go and read it. The notes are sold and what we would do, by the way, is we would, in our notices of sale, without an official statement, whether it be for $1 million note, $2 million note, or a $15 million note, we did somewhat out official statements. It ran the gamut, and there was no right and wrong of what to do. But we would say in the notice of sale, if we didn't have an official statement, that, hey, underwriter, you've got to be aware here that you need to comply with this limited offering exception, and, you know, basically on you if you don't, not our problem. And it was on them, and that is where the regulators took a look. So the exception precisely is the notes are sold to no more than 35 persons, each of whom the underwriter believes, not you, not us, not me, the underwriter believes has knowledge, they're experienced in financial and business matters, and is capable of understanding the merits and the risks of your notes. And the underwriter also reasonably believes that these 35 people are purchasing for not more than one account, i.e. for their account, or they're not purchasing with a view to distributing the notes down the line to other people. Limited offer, again, $100,000 denominations, you don't worry about that, that's all taken care of. But more to the point, that the SEC believes that if anybody is going to put down $100,000 on a note, as opposed to maybe $4,000 or $5,000, that these are going to be the sophisticated types. It protects the securities from getting into the hands of people who don't have the knowledge and experience to do with it. The SEC objective, as Michelle was saying earlier, to protect the general public, the notes would go out without an OS, but they're only held by a small number, sophisticated investors with investment intent and who possess the necessary knowledge and experience to evaluate your notes, not going to the general public. So that was what was relied upon by the underwriters when they bought notes over $1 million for a year without an official statement. Then the next slide. And yeah, okay, now let me go to the next slide. Oh, yeah.
Bob?
Yes, Bud.
Real quick, is there a difference to the SEC between a sophisticated investor and an accredited investor?
Wow, isn't that a great question? That is a knowledgeable question, and I'm not going to be able to give you all the precise SEC answers on that, but I can say this. The SEC, so there is, and this is going to go down a rabbit hole here. So
glad to help.
There are certain types of offerings that only are allowed to go to accredited investors or sophisticated investors, qualified QIBs, qualified institutional buyers, and those rules are all defined. And sorry, but I'm just going to rattle these off, but not that I know them. There are limited offering exceptions for securities law purposes. There's Rule 144 this, there's this and that. Interestingly, Bud, purposefully, when the SEC adopted 15C212, which is different from there are other rules that deal with in corporate securities and municipal securities about QIBs and accredited investors, sophisticated. Yes, I think the answer is there are certain differences and they are certain defined terms, but that was left in that box over there for other circumstances. And when the SEC adopted 15C212, they purposely did not use those terms in order to be more flexible for the underwriters. So they left it to the underwriters to make their own reasonable belief and judgment that these folks were okay, so to speak, without making these folks meet these definitions of those terms that you just mentioned, which appear in other areas of SEC stuff. So I don't know if I even answered your question, but I think the short answer is yes. Is there a difference between the two? I think there may be a difference between the two. And I think that they are particular terms that are defined by rules and maybe even rulings in other contexts, but those terms are not technically applicable to these 35, though it may be that the underwriter men making their reasonable beliefs may focus themselves on what those things are in order to inform their reasonable belief. Did I come anywhere near?
Yes. And the reason I asked is some people use those terms interchangeably, and I was of the thought process that they're not interchangeable.
I think that they're not, and the differences are slight, and those are used in the context of limited offerings, where you have some crazy, which we don't deal with, right? We deal with kind of mostly normal offerings and rated offerings. But if you get into the world of unrated debt, those are usually specified, and they try to exempt from, it goes more to the exemption from registration in quasi-corporate municipal deals than to this particular one. But it all is kind of confusing, and there were comments when the SEC sorry about all this, there were comments when the SEC adopted 15C212 is, why don't you use these terms that you use elsewhere in determining a securities exemption, a registration exemption? But they chose not to. And I do think there are different parameters and definitions out there for those two terms. But yeah, most of us just kind of say, yeah, they got to be big boys, was the terms that came out of historic stuff that we want sophisticated, and I kind of ramble them together often, but their particular definition is not does not guide this particular rule, strangely enough. But thank you for thank you. Now I'll try to dig myself back up to the top.
Thanks, Bob.
Thank you, bud.
Hey, Bob, before we move on, sorry, I was just going to launch the next polling question really quick. So this next one is, have you used an official statement for bond anticipation notes in the past?
Oh, I'm interested in that.
Yeah, make sure you get your responses in, and then I'll share in about 30 seconds or so. All right. All right, you should be able to see the results. It looks like mostly yeses, some nos, and then some not applicable.
Right. So that's good. So those of you who have, and this is for notes, you know, everybody, as Michelle went over, there really are no exceptions for bonds. None of these really apply for a bond issue on a competitive sale. So you would, I think, never on a competitive sale ever not have an OS for bonds. Have to be a very, very unusual circumstances. But for notes, it's been a 50-50, and 50% of you have used an OS, and I saw somewhere in the 20s hadn't, and maybe some of those in those 20% are not the ones that are not planning to do a note over $1 million. So the percentage of you that are doing the note over $1 million that haven't used an OS before, this is of particular significance to you. I think that even those of you who have used an OS for your notes will be interested once I move myself on here, which I don't want to do on this slide yet, but when we you'll be interested a little bit in what the market dynamic is looking like at this point, which I'll go over quickly. So I think I've covered this slide, which is exception number 4, the limited offering exception. And now what in the world happened last year, and why are we here? Why are we talking? So last September, the SEC was not happy with what it thought were notes getting into the hands of the general public, and they blamed the underwriters. They can't blame you, they can't blame us, they can't blame deposit banks because they have no regulatory authority there, but they blame the underwriters for in essence allowing the notes to move downstream to the general public without taking the precautions they're supposed to take. And the SEC was unhappy. So they had in September 13th, there were 4 enforcement actions, meaning that the SEC went after 4 of the primary note bidders in our market now and prior to that put in bids all the time, and that's BNY, Oppenheimer, Jeffries, and TD Securities. I get them right? Yeah. So they went after all 4 of them. Now, there had been a little bit of a buzz in the marketplace that something was afoot and something was brewing for a number of months, and then it came out. 3 of the underwriters settled without, whatever those words are, without denying or admitting any wrongdoing. They settled with the SEC. They promised, we're not going to do with this anymore. Whatever it is, they got your ire up. We're going to put in procedures to make sure that doesn't happen again. And they paid. The NY paid about $1 million, maybe more. 2 of the others paid in the 6 figures. Any note issue that they did that the SEC didn't like, if they made any profit, they had to give that over. They had to disgorge that. They were had penalties. So this was money to them. All of a sudden, a lot of all their profit from those note sales evaporated. Oppenheimer, last I checked, was that they had not settled. They were they were going to take this down the road into a litigation mode. I think somewhere I saw that they made the amount in play, which maybe is why they want to continue, is a couple $1 million. So the SEC said in its release that we encourage, which we've seen in the MCDC years some time ago, the SEC encouraged other underwriters who feel that they may have been doing some similar things to come and talk to them, and it would be better for them to do that than for the SEC to come find them. And there have been, indeed, there have been a couple other settlements, one in December with another one of our bidders, which was PNC. And then just this month with KeyBank, which I think does most of its work out in the Midwest, doesn't do as much here. So what the SEC described is that the underwriters sold notes without an OS to broker dealers. In other words, the underwriters didn't, when an Oppenheimer buys this, they're not buying it for themselves. They're buying it for other broker dealers and investment advisors. And those broker dealers and investment advisors then also weren't holding for themselves and were putting them into various accounts. And the SEC said, so how is this happening? You as underwriters should have expected this. The broker dealers immediately resold the notes. And you as underwriters, who we have regulatory power over and can tell you it's unlawful if you don't meet this exception, you did not have a reasonable belief that the notes were being purchased for investment purposes as required by the exception. And then on to the next slide. And just to wrap up, what's happened, and then we'll talk about more utility stuff, like what we can do and what we are doing, and what you and your financing team will be thinking about. This just goes more on to why the SEC really proved their case. The underwriters did not inquire. Underwriters could have protected themselves if they had put procedures in place to be sure that the people they were selling the notes to, the big funds, if they did it, if they had signed an investment letter that said, listen, we're going to hold these notes, then the underwriters would, but the underwriters had no procedures in place to take care of this, to prove out that they had a reasonable belief of what was going to happen down the line. So I think I can skip the rest. The bang here of this slide is that the SEC said, we got you underwriters, and the other underwriters came in and settled. So what do you and your financing team, how do you decide? So you still might be able to meet an exception, and how do you go about determining whether or not you should produce an official statement? And this is for your note issue. And this has always been on the table as a decision point. There's nothing new about it. But what is new, and which I underlined and actually moved up. I first had it at the bottom bullet point of this slide, but it is now the top bullet point, because again, it is why we're talking about it today, and why there has been an adjustment in maybe an adjustment in your decision making, is the bidder requirements. Since last September, most underwriters do not rely anymore on the limited offering exception, as we'll see in the statistics on the next page, and instead they require an OS. So now, if we've done what we always used to do, you have lost 3 or 4 underwriters. They simply won't show up. They won't bid. They don't want to mess with it. They're too concerned. There are a couple that were still there, literally a couple. Not to say that they'll come out every time, but you've lost. If we had 5 normal bids, and I'm not talking about at the moment deposit banks or non-underwriters, but if we had 5 bids and we've lost 60%, that's something to know, at least when making our decision. So other things that go into making a decision of whether or not to use an OS, or what should we do, length of time. So as Michelle correctly said, it shouldn't be viewed as daunting. A lot of this stuff is uniform from town to town, except for certain areas, your ordinances and so on. But the basic law, the budget law, the bond law, that's all going to be the same. Different professionals might have a touch of a different way of saying something, but they're all coming to the same place. So it's not a daunting task, but then again, it's not a one-page notice of sale, which we can put together overnight or in a day or two. It's something that's going to take a couple of weeks. You got to compile the appendices and the financial information. It all got to be put together. Somebody's got to draft. Somebody's got to review it. It's not a months-long process, but it is not a days-long process either. It will take a little bit longer. So you have to have the time, and you can't, if you run too close to your note rollover, you don't have an option anymore. So you want to think about this and at least make the decision earlier in the process, so you have the flexibility to make a decision. Also, not only the length of time, but it's, availability of people. Not only does it take a little time, you've got to have the time within the time to be able to put everything together. It does have a cost element to produce, which is often, as we'll talk about in a bit, often the savings from doing an official statement will offset the cost. You can't guarantee that, but that's usually the case. And the cost that is that it does take for your professional team being ourselves, the bond attorneys, the auditing community, and also the financial advisor, municipal advisor community, if you have one involved. They're all going to chip in, and everybody's doing making the whole product. Either one person's got to make it all, or you have different elements put together. The cost of doing that is typically included, or can be included, not to go outside of my area here, but I think it's generally viewed as a cost of issuing the notes or the bonds. So that can be tucked into your Section 20 expenses and your bond ordinances. The amount of interest rate savings is always interesting. I'm going to talk about that in a bit. It's very, very tough to quantify, and it depends on a lot of factors. Just for sake of discussion, and I'm not saying this is it. So let's say it might be 40, 50 basis points, depending on circumstance, rating, and so on. If you have a $10 million issue, and you have a 50 basis point savings, or you have a 5 million, the size of your issue, you have double the savings of on a $10 million issue that you would have on a $5 million issue, and so on down the line. So the size of your issue affects the amount of your of your savings. Also, the general interest rate environment. We, for years, have benefited from a tremendously low ban interest rate environment. You probably had notes go out in the last couple of years. They could have been under 1%. You may have even gotten under, we had some go out for, 0.3, 30 basis points or something. So obviously, if you have the interest rate that because of the rate compression, if you have the notes are selling for 40 basis points, you can't save 50 basis points by doing an OS. There's just not, there's not enough to work with there. But now rates are on notes are somewhere between 3 and 4.5, depending on a whole, soup full of things. But that is your general range. So that is much different from being under 1%, and there's much more room to realize savings and interest rate differential. Other market conditions, not too much there, but the market conditions now might be different than they were 3 or 4 years ago for various reasons, and that may affect the need, desire, or the bidding community as there has been a change. If credit is tight out there, you don't have lenders want information, they have more leverage. And you do have a new continuing disclosure. If you do an official statement for a note and you've never done one before, maybe within that 25% of you, or if you have a new continuing disclosure obligation, but it's not a biggie. So the continuing disclosure, generally, you have to provide financial information annually, and you have to provide notices of certain things happen, which they rarely, if ever, happen, but you have somebody monitoring that. For notes, since notes mature in a year, you're exempted from the financial obligation side of the reporting, because by the time you get your next year's financials up, the notes mature. So so you really only have to give notice of events. And as I say, those events that's a different seminar or webinar, but you really the on a note issue, you don't have to worry about events. So even though you do have a new continuing disclosure obligation, it's probably not something that's meaningful in the real sense. Let's go to another. So what's going on? When this thing hit last September, we were in trouble. We had note sales scheduled in October, and it was too late in most circumstances to produce an official statement. We didn't know what was going to go on. We didn't know how the bidders would react. And we talked to clients and we said, the best we can do here is try to give us a buffer zone to schedule particularly if we have a rollover, if it's new money, okay, so you postpone the note sale for 3-4 weeks, it shouldn't be a biggie. But if you have a rollover, you need your rollover money in order to pay your maturing notes. So you're a whole different context. So what we did is we tried to roll back the note sale. Usually we sell 10 days, 2 weeks before the old notes mature, enough time to get out all closing papers and so on. But if we were going to have a problem with bids, 10 days wouldn't necessarily be enough to reschedule the bidding. So we backed that up a bit because we didn't know what was going to happen. But now, what we said is what we thought would happen, which is over time, this is going to play itself out, and we're going to know what's going on, and we're going to have information about how the market has changed or not changed, and that indeed is what we have at the moment. So bullet point 1, why we're here. Most underwriters no longer submit bids on 1-year notes of $1 million or more unless there's an official statement. So done. We had a sale earlier this week, end of last week, and the financial advisor on the sale produced a little booklet in advance of the sale and let us know some of comparables and what was going on, and also had a chart of what's gone on and they keep track of, I think I didn't want to produce their work product here. I didn't think that was right, but they had a listing of all note sales this year in New Jersey, and so I went through that, and hopefully my numbers are close to being right. I may have miscounted here or there, but here's what's up. And I didn't focus on the note sales under $1 million. That wasn't, that wasn't particularly relevant to change. What I did look at is, were there note sales? Were people tailoring? Were they to try to meet the 9-month exception instead of the 12-month? Was that a solution that folks were looking for? And I chose maturities and this is all data, Jan 1 through March 24. I chose the notes that have maturities of 7 to 9 months. I thought if it was less than that, like 3, 4, 5 months, that probably wasn't purposeful to evade the OS, but more was in advance of a planned bond sale, since they weren't going the full. So I only looked at those, and what I came up with was there were 4 sales that were tailored to that 7 to 9 month period. Important point here is that if the first quarter of the year is particularly tricky, because if you're going to tailor a 9-month note in the first quarter of the year, that means you're going to mature this year, which means you're going to have another interest payment this year. So it's not budget neutral. So maybe we'll see, starting around now, we're out of the first quarter, and maybe there will be more activity to do notes to 9 months instead of a year. For example, April or May, go to 9 months, get into January, February. That you'll have the same issue next year. So I don't know that solves it unless there's a decision, which could be a viable decision, that, yeah, maybe, well, it's worth it. 1 year we'll have an extra budget payment. But anyway, that didn't seem, at least in the first quarter of the year, that there wasn't a lot of action there. So of the number of 1-year note sales of $1 million or more, there were 39 of them in the state. In the first quarter up to last week, 32 had OSs, 7 did not. Now, all this data, as all you guys know a lot better than me, that numbers, it's all in the detail. So it's, you can't just go off these numbers. There were actually a lot of larger note sales in the first quarter of the year, and they may have naturally used official statements anyway, since they may have been in the $10 million or more range. So it's not necessarily fair to say that that all this 32 to 7 disparity is all due to this new rule. There's probably something in there along those lines. What was interesting to me also was, I said, what about bidders? Am I getting bidder activity? What's the difference in bidder activity? So on my OSs, I have 4 to 5 average, closer to 5 bidders, like we always had. Again, maybe some of these sales were larger, so they brought in more folks, but this is an average. So this also includes sales of, $3 million or $4 million that also, had an average of 4 to 5 bidders come in, and 21 out of those 30, again, all numbers, but they show trends, had more than 5 bidders. We are seeing these days, 5 is, and these are, these are underwriter bidders primarily. The average number of bidders without an OS, 2, maybe sometimes it gets to 3, but usually 2. A little bit striking. 4 of those 7 only had 1 underwriter that bid. So it's not as a robust bidder community and market for those. And that, I think, is the, kind of the big takeaway to factor into decisions. Only 2 underwriters now, BNY and Piper, will consider bidding if there is no OS. Interestingly, then BNY will do it. Now, I called one of them this week. I said, why you? Why are you comfortable bidding? And the other guys aren't. What do you know? What's going on that you feel better about it or not? And the honest answer was, well, listen, if we know in advance that we have the note sold to a customer that is willing to sign a letter for us saying that they're holding it, we're clear. We don't always know that. when we do know that, we feel if they have a particular customer, we feel then we can bid because we're not afraid of violating this rule. We can evidence that we are in compliance with it. So that is when they will bid. But you know, the problem is they may not know, you don't know that necessarily when you're putting out your notice of sale. I think, you know, I wanted to check the 32 sales, you know, with the same 2 underwriters winning those 32 sales. Did it really make a difference? And of the 32 sales, 24 were won by non-BNY and Piper, meaning that, you know, the other underwriters that were coming to play were winning 2/3 or 3/4 of the time. And our traditionals are back in. Oppenheimer, Jefferies, TD Securities, they're back in and they will bid with an OS. Again, interest rate differential is, I don't even know where I'm going next here, but before I do, the interest rate benefit is, you know, impossible really to quantify for using an OS. You know, it is interesting. We had this week, earlier this week on the same day, 2 towns that were rated the same. They both had the same par amount of their note issue, around $7 million. And there was one had the disclosure document, the other one didn't. And there was a 48 basis point differential around 50 basis points. It's not to say that that was all because of having the disclosure document, but certainly a lot of that was. And similarly, there was one on the same discrepancy, about 52 basis points, kind of similar last week. So lastly, I'll finish up, is I guess on the, you know, so, you know, okay, what does this all mean? What can I do? What are my options? And I think, how many are there down there? There's 6. I think you in effect have 6 options. And again, for some of you, it's not really changing because you're doing what you did do. You're producing an official statement. You do know the market a little bit now. Now you can see the value of what you're doing. You know, and for example, just going to the interest rate thing, if it is really a 50 basis point difference on a $10 million issue, what's that? I think that's about $50,000. And you wind that back to, I don't even know if I got my numbers right, but I think most of the time, as the issues get up, your interest rate savings are going to offset. Not all the time, but I think a lot of it. So my options: I'm under $1 million. Don't bother me with all this. I'm 9 months or less. I don't have to worry about it. I'm going to get bids. I don't need an OS. There's no requirement. I'm not relying on this limited offering thing that gave the underwriters problems. I'm relying on something else. If you do that, you have to factor into just factor in at some point that 9 month. You may not want to be. You may have a double interest payment 1 year if you continue to do that. No OS and no underwriter. You can't be assured when you put out your notice of sale who's going to bid. You can do a negotiated sale. That is not a competitive sale. You can talk to a bank, your deposit bank, and see if they want to pick up your note. And if you feel that they say yes, I'm in, and you can rely on them, and they quote you an interest rate that seems fair and on market, you're also done. But I think that is more difficult as the size of your note issue goes up. You could also do a negotiated sale with an underwriter. Again, it's not competitive. You can call up one of these underwriters in advance and tee up your sale. That gives them time to find their customers, as opposed to putting in a bid and not knowing at 11 o'clock when they're bidding. They have no idea if they're going to win or if they're not going to win. So sometimes they don't have customers lined up because it's just too much trouble. So if they know in advance, they may be able to work with you but that takes out the competitive nature of the process. A competitive sale is not legally required for notes. It is for bonds, but you can do negotiated. The fifth option is you can do a competitive sale without an OS, but somehow you want comfort, I think, and when talking this through with financial teams, we've been about, if you do that, you don't want to open up on bid day and find out you got, neither the underwriters bid, and that the only bid you got, there was one sale in here where it went over 5. You don't want to get stuck with something. And I don't know how you get that assurance, but if you feel you can get assurance one way or another that you can tee up a competitive sale and not use an OS, and somebody's going to show up and give you a competitive bid, that's fine. But you don't want to be in a situation where you look at your screen and nothing's come in, and you have a rollover coming due in 2 weeks. That's an uncomfortable situation. And lastly, you can do an OS, if you now have your competitive sale with your OS. But the most important thing here is the bottom, you're going to work with financial professionals who are out there every day, who know you and who can see what's going on and what might be right for you. This is not saying there is absolutely no one shoe for everybody here. It absolutely not that, but this is a new development in our area that at least should be discussed, considered, as you put together your plan. I think
Okay.
I'm slided
I found this
out.
on the web for how do you put together your plan? Check it out.
Now I got Siri talking to me.
Hey, Bob, there was one thing that came up with your options screen. One of the questions was, if it's over $1 million and under 9 months, is the OS needed?
Over $1 million, under 9 months, no legal requirement for an OS.
Thank you.
You have a blanket exception. You don't have to rely on exception 4, which was the trouble one. You can rely on whatever it was, exception 2, and that's enough.
So,
And we may see some movement in that area now that we're out of the first quarter. Not sure yet. We may. We're going to monitor this.
so Bob, isn't there one more exception? What if in Bergen County is doing this, we're doing a $240 million pooled note program. And we're going to anchor the deal with our notes, and then we're inviting all the towns to come in so that they can forego the cost of preparing an OS. We issue it.
100%, John. If you go through an improvement, the improvement authority has to worry about what they're going to do, but you technically, no, that's exactly right. You have another yes, that in effect, I think, and I'm trying to analyze it as I'm flying here. I think that would technically be, you're selling, you still have a municipal security, but you're selling it to the improvement authority, which is a governmental entity, which is a non-underwriter. So the improvement authority does not have to worry about. Yes, so the improvement authority as the conduit can do it for you, and there is an exception for the improvement authority to not get an OS when it takes your note. Yes.
Okay. So we're doing one in June and we're doing one in October to entice people in, to give them avenues to go through. So any Bergen County town that's on this call, you have an option.
Hey, Bob, is there some disclosure requirements in a pooled financing like that if you are some higher level percentage of the pool?
Yeah, so that's a great question. Again, bud, you're drilling me another hole to go down here, or I'm going to drill it. You're putting these things out there, so I think it's a easy turf. And then I'm going to answer, but also then say that it is going to be ultimately the financial professionals for the improvement authority who are going to relay back to their to its borrowers what their threshold is. So typically, and I've done work with a couple improvement authorities, there there is a threshold of the key is when an issuer, being an improvement authority, somebody else, when an entity pays so much of the debt service of a pooled issuer that it is considered to be, going back to what Michelle was talking about earlier and disclosing all material information, there is some threshold, it's not defined in law, by the way, there is some threshold of payment of debt service, some percentage people conveniently use now and then to say, well, hey, Bergen County or Morris County, whatever it may be, is doing a pool. And they got some towns involved, for 20, 4 or 5 towns, each making up 5% of the pool. And then they got Bergen County itself is borrowing 80% of the pool. They're in Magilla there. So the thought in the industry is that that particular borrower is such a material part of the debt service payments that is enough that they should disclose about the financial information about that particular borrower in the appendices of say that pool loan or the improvement authority's issuer. So that's the measure. And going back to the minutia of 15C212 again, that the general design there is if you've made a decision that something is material enough to disclose in the initial primary offering, there should be an obligation to continue to disclose on those same things over the life of the bond issue. So my familiarity with improvement authorities is they different professionals or different improvement authorities may use, and John, I don't know what Bergen may do, they use different thresholds. The most common thresholds for percentages of when you want to have disclosure of the underlying borrowers is either 10 or 20% of debt service. John, does that sound about right? It goes different ways, but those are the typical ones I see.
Sounds about right.
Yeah.
Just so you know, we make up 74% of this issue so far.
And Bob, it's still easier in that the like Bergen County did, their participation in the BCIA sale, that they still don't have to prepare an OS. BCIA may have to, but not Bergen County itself.
That's exactly right. The issuer of the securities notes, if it's a pooled note sale, the issuer of the securities to the public, to the underwriters, has to produce the official statement, not the underlying borrowers. So the improvement authority itself has to produce an official statement. And then it's, unless they can qualify for an exception, which they're not going to be able to qualify for, presumably, and then the underlying Bergen County doesn't have to produce its own official statement, but it may have to drop in some of it. Bergen County might have to drop in some of its financial information into the improvement authority's official statement if they go over whatever threshold the professionals or have decided to use.
That is what we're doing, and the county is guaranteeing the entire pooled note,
which is even more to the point that John, which is good because that steps up the credit because Bergen's AAA. But that even if Bergen County itself were not borrowing from the note proceeds, because it is a guarantor and so essential to the credit and to the buyer, it is likely that even though in that circumstance, even if Bergen County were not a technical borrower, as a guarantor, it would likely include some of its information, which you would want. That's why you're getting the AAA rating.
Looks like we got one more question.
Has everybody, do we have participants now like in the neighborhood of 4 from 70? Has it gone down?
No,
So
we still got a lot.
Next question was posted, Bob, was, isn't there still a cost to municipalities to participate with the county? The answer there is yes, there is.
Yes, I'll leave that to the, to the Improvement Authority of financial people to speak. Yeah, of course, there is a, there are other, yes, there.
I mean, there are other benefits to participating in an improvement authority, that you can waive the requirement for a down payment. There's other things that you can do and benefit from that. But there is a cost. But I guess what you need to do is weigh the cost of preparing your own OS versus joining the pooled program, and if there is a cost benefit.
Right. Most of these things are, as John says, are cost benefit, and also, not only dollar cost, but, just time, which is, they say time's money, but it isn't always, but.
So the other thing, that just so anybody, if they're interested, if your timing is not a June or an October, we had one of our towns that wanted to be in the program, but their note was coming due in April. So what we're going to do is we're going to buy that note for 45 days at the county and get them over that hump to get to the next, to our pool offering.
That's good. It's a good solution. It's there
Bob,
still, yeah.
You had
No,
mentioned
Bud, I don't want any more.
the same vein. You had mentioned continuing disclosure in these pooled arrangements. What kind of continuing disclosure would, say, a municipality have in a pooled offering if they were, met that threshold of 10 or 20%?
Well, so another I should, you're going to make me go for more coffee, Bud. So it's all driven by what the initial disclosure is. So the SEC really says, in the corporate markets, and I don't know anything about corporates, I really don't, but you hear that they file annual reports, quarterly reports with the SEC, and none of that has ever happened in the municipal market. Now, yes, here in Jersey, we have all this great stuff and websites, and your financials are supposed to go up online and all that, so it's available. But there has been no federal requirement to have any continuing disclosure on municipal debt that can go out 20 years or so. So what the SEC basically said is whatever you disclose, basically, whatever you've put in there initially, we want you to update on an annual basis. Let's say it's financial information. Let's not talk about notices at the moment of these odd events, which for the most part, and again, we can talk about that some other point, for the most part aren't going to come up. So if an improvement authority, and some that I've done, have if you're let's say you're over the threshold, your particular town is borrowing 25% of the overall. If your town's only borrowing 3% of the overall pool, they're not going to put any financial information in on you. So you have no continuing disclosure obligation that I can think of with respect to the improvement authority's issue. If you are 30% of the issue, they likely have put in something similar to what Michelle was talking about. She talked about two financial appendices. One is the audit, and the other is a compilation of 6 or 7 pages of really material that we call Exhibit A or B, depending where you put it, that's really been extracted from the audit and put in chart form to make it easier for the rating agencies and the buyers to take a look at it. So, and I don't know, any improvement authority can carve their own wheel here or whatever they may be doing, but often you will see, will the audit go in for a 30% borrower? Maybe more likely they'll put in the 6 or 7 page appendix, which you might be tossing up online anyway for your own disclosure. Who knows if you're doing it, if you have a disclosure obligation. But I think, Bud, if I got you still remembering your question, that the disclosure that you as a town would do if you are a disclosure going over the threshold is going to be similar to what the authority has asked from you at the time that they originally sold the debt. So if they asked for financial information at the initial time you sold the debt, and they put that in, you'd have to do that. Now, I'm just thinking of a caveat, because there are always darn caveats here. As I mentioned earlier, at some point, I think that on a note issue, even if they put financial information in with respect to you, because you're over that threshold, on a note issue, you do not need the SEC requirement says, hey, it doesn't make any sense to require you to continue to put financial information up because it's only a note issue, and your next financial information is a year away and the note will mature. So no matter, even though you may have, in that context, even though you may have initial disclosure to put financial information in, if there were a note, you would not have to update that. Would you have any other disclosure obligation on notices? You might. There's this new one out there that if you've incurred a financial obligation, you may you may have a notice, and you may then be have to notify the improvement authority, who might then have to put it up on Emma's. But so I don't know. Once again, did I come close to the question?
Mm-hmm. Yep. Thank you.
Before we move on, we had one more poll, Bob, on this presentation. And I think it was relating to what you guys were just talking about. So for this one, for required EMMA, continuing disclosure, filings, do you, and then there's a couple different options there. So I'll leave this open for a minute.
I'm interested in this too.
Mm. All right, make sure everyone responds. Okay. All right, you should see the results. Looks like most people use a continuing disclosure agent to make and assist with the filings, and a couple of the other ones.
That's good.
Thank you.
It's a technical area for those of you, and I see, you know, to the ones that are relevant. You know, often you're using a particular professional or vendor to do it, and you know, as with anything, a filing and regulatory requirement doesn't get simpler over time. So, you know, these folks stay on top of things and the changes, how to file, making sure there's no, you know, you haven't attached the right QSIP or something odd there. So I think they're very, I think they provide a very useful service.
Hey, John, before we end this session and get to the next one, I wanted to thank Bob, Michelle, Jason, and Mon, in case they have to leave. Even though your riveting session is next, John.
It is riveting. And it'll
I'm
be very
staying
brief.
too.
So Bob, Michelle, Jason, and Mon, thank you all very much. I thought you guys you all did a great job.
Thank you.
Thanks so much for having us, inviting us.
Well,
Our
you guys
pleasure.
did all the work. I haven't been around.
Well, that's normal. All right, we moving on. The next one is going to be a little bit more brief. It's talking about local finance notice 2022-24. And me, like most of you, probably looked at the front sheet when I first looked at this, read the first two paragraphs and said, oh, great, we got to do another certification when we're buying stuff. But if you read further into it, this was passed back in March, on March 9th, 2022, it actually was signed into law. It was Chapter 3 of the Public Laws of 2022, and it required the State Department of Treasury to develop a credible list of persons or entities engaging in prohibited activities in Russia, Belarus, and then they combined it also with the Iran disclosure. And the list is available on the website. But when you read a little bit further and you get to the second page, which most of us didn't flip the page, it goes on to say that as the new law is now alive, before any contract, and it says any, greater than $1,000 for goods or services is awarded, renewed, amended, or extended, a contracting unit shall, and this is where it gets to be fun, we have to get that determination. We have to get certification from the vendor, and we have to go to the state's website, Treasury's website, to make sure that they're not on the banned list. What's interesting is you would think that they would do this through the BRC process if the Treasury Department was already tasked with figuring out how to enforce this, right? So if there's not a valid BRC, you go to look it up, it would be a one-stop shop, but that's not what they did. And then it goes on to talk about all the different requirements that we have that we need to rely on that list. And then, like I said, they combined it with the Iran disclosure. Now, it goes a little bit further, and we all understand why this is put in place. It was feel-good legislation, and to have an economic impact on Russia, Iran, and Belarus. But they started to reach even further and say that this also impacts your ability to have a redevelopment agreement or pilot agreement, that those people need to be cleared as well. So that's it. So I don't know if you can do a question on the fly, Katie, but how many people knew that this was $4,000 and greater?
Yeah, I can put one in. Just give me one moment.
Now, I do know that John Buck from MSI was trying to work on a fix where he could actually match the names on the list to vendors that might be in your file to help you through that process. But if you think about the administrative process for this going forward, is to have I was hoping Jason would come back in on this one, but to have the requirement for anything $1,000 or greater that you have to get that certification administratively, it's onerous. Now, I was going to end with that the division is looking at doing a refresher, and I think that's why Jason popped back in.
Yes, John. Thank you, everyone. Basically, we anticipate we're going to be issuing very shortly an updated or a supplemental local finance notice on Russia, Belarus. There have been a number of questions that have come up. Various presentations are just sent to us or to my colleague, Michelle Mead, who's our procurement specialist. And that will anticipate that LFN will address a number of those issues, as well as the issue of the threshold. Now, I know my colleague had presented it earlier this month at the league seminar, and I anticipate our guidance is going to say that if you're something to the effect that if your attorney is comfortable with the approach that, okay, state uses its quote threshold, so we could use our quote threshold. No, we're not going to stand in the way of that. So I think that's the tone we're going to take in the upcoming guidance.
Which I think provides a little relief.
Sorry, John, I'm going to launch it. Just want to make sure. Did you say $4,000 or greater?
1,000.
Oh, 1,000. Sorry.
And we just had a comment from one of the participants saying that they actually just made it a part of the purchase order terms and conditions. We need the Jeopardy music.
All right, I'm going to launch this poll. So did you know prior to today that the threshold was $1,000 or greater? It looks like, again, we're going to be pretty split, 50-50.
Yeah.
Right. I'll go ahead and share.
See?
Yeah, pretty much. Mostly no, but half and half. And then, John, we had another question. Did you want me to launch that one? I think it was similar about the $1,000.
Yeah, no, that's okay. I think that one was.
That one's good. Okay. Got it.
And we're just
Thank
at
you.
the end of our session anyway, so we've got everybody still awake.
Yeah, right.
I had a quick presentation on the Financial Data Transparency Act. It's like 8 slides long, so I could just email everybody the PowerPoint if that's how they want to do it. Bottom line is that there's more changes coming for the MSRB EMA website. There's going to be some more. It's going to be different because they want you to have some continuity. The way I look at it and the way I read it and understood it was years ago when they implemented FAST down at the state. The idea was that we can take and extrapolate data and information and compare one town to the next. I think that that's what the Financial Data Transparency Act is trying to do at this point, trying to organize the information a little bit better, not so much require new information to be posted up to Emma, but in a different type of format. And it's still about 3 years away from full implementation on this, because they do have to go through their public comment period and all that. So it is a ways out, but just to let you know, that could be on the horizon of how we input data into Emma going forward. So I'll send those slides out to everybody. Again, it's only a handful of them because nothing's set in stone yet, other than the law was passed. But again, you gotta pass the law before you know what's in it. So yeah, other than that, I've got nothing. So John, anything?
Nothing else.
Just quickly before we wrap up, I was going to launch one more poll just to indicate everyone's preference for our next CMFO roundtable. We're planning it and are debating doing it as a hybrid event with both in-person and webinar attendees. So if everyone could just indicate which way they would prefer attending, I think we're planning for June. And then the second question is, if you are unable to attend in person, would you have any objection to the hybrid setup for the seminar? Thank you, everyone, for taking a minute to respond.
We ask if they want to have a Bloody Mary or mimosa bar there.
That'll change the responses, I'm sure. All right. Great. Thanks, everyone.
And there were 2 more questions that popped up while we were going through that. So looking to get language if on that purchase order. I know somebody said they were doing it on a purchase order. I don't know if there's standard verbiage that everybody can supply.
Actually, that was Joe Kunz from Clifton. I know, Joe, if you could email a copy to someone at Nisivoccia, that would be great.
Then we can get that around with the PowerPoints as well. And then the last is, so there's a chance that it might eventually be updated to be only required at the bid threshold instead of all purchase over 1,000 as far as the investment in Iran, Belarus, and Russia.
I don't believe he said bid. I think he said quote threshold.
Quote threshold, yes.
Yes.
Threshold.
Yeah, like I said, we'll be issuing an updated local finance notice with that and other clarifications.
Right.
No more questions?
You get the results of that, Katie?
Yeah, it was pretty split. You know, still a decent amount for webinar, which I thought might happen, but there were a good amount for in-person too. So, and then some not sures, which.
Gotcha.
So looks like we might be doing hybrid next time, which is good. I just want to remind everyone, like John said, we'll send out the recording and the presentations from today, and also the follow-up survey that you have to complete for credit will show up in the browser when the webinar ends. And I'll include that in the follow-up email as well, in case you don't have a chance to complete it.
Okay, great.
Great.
John, you wrapping it up?
Yeah, sure. I just want to thank everybody for coming today. I want to thank our speakers. Were excellent. Great job by all. Just couldn't do this without you guys. A huge help. So we're going to look to hold our next one, like we were saying, maybe in June. Hopefully do this a little bit hybrid, just depending upon the feedback that we've got today. We'll discuss it, come up with some new topics for you. And everybody get out there and enjoy some hopefully good weather this week. I haven't even looked, but it's getting nicer out. So getting the itch to go out. Again, appreciate everybody's participation, questions, as always, like John said earlier, you know, this is a round table. We want to get everybody's opinions on the table and questions out there. That's what makes this go. But we did fill a complete 3 hours today. So again, thank you for your participation and continued thanks to those who presented. So, Bud. Good.
Yep. Thanks everyone for all your work. Appreciate it.
All right, guys, enjoy the rest of your day.
Yeah,
Thank you. Enjoy the weekend.
Thank you.